requirements, let's look at some of the key provisions of a well-drafted will beyond the statutes. You definitely want a team member talking to your client who's going to talk to them about what are their ultimate distribution goals. And here we're not just talking about wealth transfer. We're talking about what are your goals for your children? What are your goals for the surviving spouse? How do you want this money to be distributed? In Texas, a person can give their money away in any way they see fit. Spouses do not have to leave money or to leave their estates to one another. However, you can only give away what belongs to you. And since we are in a community property state, typically a married couple owns only half. They each own a 1/2 interest in the estate. So at the time of the first spouse's death, the first spouse to die's death, they can only leave in their will their 1/2 of that community property. Another key provision in a will for married couples is a specific bequest of the spousal interest. Hang with me here. The spousal interest in the surviving spouse's life insurance and retirement plans. A highly technical area of law surrounding that. Because we are in a community property state, sometimes the results of that can be quite surprising to clients. So that's an area that definitely needs to be planned with the plan administrator, the agent who's familiar with the life insurance policy, as well as the attorney in order to meet the client's goals. Another important part of a will is a residuary clause. If a will does not contain one, you have a partial intestacy. That's the worst of both possible worlds because you've paid for the will, you've got to do probate, but then you've also got to go through intestacy proceedings. The fiduciaries that your will is going to appoint are going to be an executor and a trustee. The executor is in charge of carrying out the terms of the will, so making the distributions according to the will, taking it down to the court, having it probated. There are certain requirements under Texas law for who can serve as an executor. Your client needs to be advised properly on those requirements. If they name a person that's not allowed to serve, or that might just be not suitable to serve, the court's going to appoint an executor for your client. Again, that is a failed goal for your client. They have lost control at that point. And the trustee is responsible for administering the terms of any trusts that you've set up in that will. Again, there are some specific characteristics to consider when picking a trustee. And if your client chooses that trustee without considering the personal characteristics of a good trustee, then it could cause the entire trust purpose to fail. So the trustee needs to be somebody who is financially savvy. It needs to be somebody who's dependable and trustworthy. Your clients might want to consider the location of the trustee in relation to the beneficiaries. So if you've got a trustee managing money for minor beneficiaries and they don't live in the same state, is that trustee really able to keep up with what the beneficiaries' needs are on a real daily basis? Testamentary trusts, another element in a well-drafted will. Testamentary trusts are going to contemplate trusts that contemplate the reduction of taxes or completely eliminating taxes if possible. Those include Q-tip trusts, bypass trusts, as well as charitable planning. This is an area where it's absolutely essential that we collaborate and work together. If the majority of the assets in the estate pass outside of probate, but we've done all this tax planning in the will and we don't coordinate those assets, it's going to miss the tax planning, the estate tax planning. So that's an area where it's really, really important to have an in-depth estate analysis with our clients at a round table, all of us together, so that we can meet all of their goals. As I said earlier, children cannot inherit money outright. It has to either go to a trustee or a guardianship will be put in place to manage that money for them. And speaking of guardianship, let's talk about guardianship for minor children. This is another area that doesn't really have to do with wealth transfer at all, but it does have to do with meeting our clients' goals, looking at it from a different angle, not just what you're going to bring to the table, but what the other members of their financial team can bring to the table. Establishing a guardianship declaration of guardianship document for minor children is extremely important. If parents don't do that, the court will do that for them. And typically courts are going to look up to parents first instead of to siblings, which might be the exact opposite result of what a family would want.